We have just one case remaining on our calendar. It's Owens versus Owens. Is counsel for the appellant ready to proceed?
Yes, sir, Your Honor.
Please come forward.
Your Honor, before we get started, I could reserve about 3 minutes for rebuttal.
Okay, I'll have to keep an eye on that.
I'll do the best I can. I often forget in the middle of this thing.
Well, it's right there in front of you, so that should be helpful, and I'll try to help you too.
Thank you. Members of the court, good afternoon. My name is Scott Snavely. I am the attorney for appellant Cindy Owen in this case on an appeal from final judgment of dissolution rendered by the Circuit Court of Holmes County from, I believe it was July 6th of 06. There are several allegations of error in this case, the first of which that I would like to discuss is the imputation of income to Ms. Owens that I believe does not comport with the required law in this case. As y'all are aware, Section 6132B allows a court to impute income to an unemployed or underemployed spouse. And frankly, in my brief, I conceded that I believe Ms. Owens meets that criteria based on the evidence of record.
Okay, as I understood the brief, the only issue is the $24,000 imputation?
Yes, sir. I believe it's unsupported.
Okay, well, I think arguably, you have a very good case that there was no evidence to support the $24,000 figure. Well, this woman, though, from the testimony, had significant skills, office managing, typing, secretarial and clerking skills. I understand the record may not support $24,000, but should we throw aside basic knowledge that she can't go out and make $24,000 a year?
Well, Judge, I think that is why the District Court of Appeals and the body of law that's been developed as far as imputation is as strict as it is, and that's to prevent a trial court from just saying, look, I know you can go do this, and I'm going to exercise my judgment on this in the absence of an evidentiary record. The fact is, I think I've laid out pretty good evidence, and the first point I would make is the imputation at $24,000 was specifically from the final judgment based upon the allegation that that is what she was paid out of Mr. Owens' chiropractic business as far back as 1998.
Well, can't we assume if she made $24,000 in 1998, that with cost of living going up and inflation, that she would make more now?
Well, I don't think you can, because it is not a situation where she was actually employed by a third-party employer. She was employed, and they used as their income and as their payment.
That's a good argument. I'm not sure I saw it in your brief, but that's a good argument.
Well,
what's its market value at the time?
And that was undisclosed by the record. That's one of the problems. I mean, the real problem with this, Your Honors, is it's unknown exactly what she could make. The only record evidence on this point from this record was that she could make minimum wage. Now, the question is, are we going to say...
Did you present any evidence on her earning capacity?
Your Honor, I did not. This is, and I will tell you, Your Honor, I was not the trial counsel in this case.
Did her lawyer there present any evidence to that effect?
She asked her what she thought she could make, and her answer was that she certainly thought that she could make minimum wage. And that is the only record evidence that I could find at all about what she could make. There was some testimony.
Why isn't the evidence that she did make $24,000, why isn't that sufficient to support the trial court's finding?
Well, I would say that that evidence was not, if you look at the actual record citations as mentioned in the brief about that, what she said is that she could not earn that. And what he testified to is, I think it was something like, for accounting purposes, we assigned her $24,000. The actual evidence of record indicates that they had one account. It was a personal account for the business and for their personal use, and there was really no specific paycheck ever cut to her. And on cross-examination, the transcript reflects that he admitted that they had never paid her $24,000 according to Social Security, and that her Social Security benefits would have reflected much less than that. So I don't think the record ever truly said she made $24,000. I think on direct he said, well, I can't remember, but it was something like, and then we quit doing that in the late 1980s, 1998, because the accountant said, maybe be better. But this was not a case where they had segregated business accounts. She received W-2 wages, and they were filing Social Security on her at $24,000. And in fact, the husband admitted that on cross-examination. So I don't think there was any evidence of record whatsoever that would support 24, and no evidence that I could see that would support any particular amount other than minimum wage.
Does that strike you as being particularly high for someone with office managerial skills?
Judge, I don't know what the market would bear in that area. I mean, for Tallahassee, I might agree with that. I would suspect that the market over there would be substantially diminished from that. And the real problem is the record evidence indicates she hadn't worked in several years and hadn't worked outside of his employ or in their, I would call it more of a joint enterprise together, really, in more than 20 years. So I just think there is absolutely no record evidence that would support that $24,000, even if maybe commonsensically it would seem that that's an appropriate amount. That is one of the things that I pointed out is the record was completely silent as to the availability of jobs in that area that would pay that kind of money, so that there was no evidence of the prevailing earnings in the community, or that she was qualified for any particular job that might pay that much. There was just no evidence of it. So I would argue, Your Honor, that if the court is inclined to agree that this record is devoid of evidence and remand, what I would say is I think it would be patently unfair at this point to give them a full second chance at the apple by letting them put on retrial evidence of employability. They had that opportunity and they failed to do so. So what I would ask is that the court consider remand based on the record, and the record would indicate minimum wage imputed to her, and then I would assume that the court would need to take another look at the alimony and the child support and the attorney's fees and all the other things that cascade.
If we do that and you say take another look, should we just close it down and say no more evidence? And if we reverse on issue one, just look at all those other factors based upon the imputation of income?
It would seem to me somewhat unfair to give them the benefit of 20/20 hindsight in honing their case so that they can specifically go back and get the same result when they had full opportunity that she did to litigate that issue. Yes, sir.
You complain about factual findings.
I do.
And the rehearing notice, I know you didn't file it, never raises those issues. Haven't we, the 5th District specifically has said, you can't complain about a final judgment unless you move on rehearing, complain about a final judgment lacking facts, unless you move on rehearing to give the trial court an opportunity to make those factual findings.
Judge,
and we have specifically cited that case in another case. We haven't come out and said that, but we cited the 5th District case. Well, why shouldn't we just affirm on those issues based on lack of preservation?
Judge, here is what I would say. The record in this case, the trial transcript from a one-day hearing was that thick. In these dissolution cases, there is a lot of evidence that is taken and done in the course of one day. I think it would be very expensive to impose upon litigants in order to accurately make factual assertions like that there's a lack of record evidence and support. I think it's very difficult for the attorney to really remember just from notes. So I almost think you'd have to order a transcript, which would be very difficult to do within 10 days.
Wait a second. I'm not focus on what I'm saying here.
Yes, sir.
If you get an order from a judge and you think that order lacks sufficient factual findings,
yes, sir,
rather than raise it in the appellate court, which is also very expensive, why shouldn't you have to raise it on rehearing and give the trial court an opportunity to address it?
Judge, I think that is a position that you could take. As you've mentioned, the 5th DCA seems to have taken that. I'm not aware of the first having required it. I do know that I'm not sure is the answer. That is a position that you could take.
Give me a policy reason. I mean, we have cited to the 5th District case. It seems like it's a lot less expensive and a lot fairer to require that issue to be raised in the trial court before us jumping on the trial judges for lack of factual findings.
I would think that it would make, from a policy perspective, it would make more sense on evidentiary objections and things like that that are less amorphous and less defined than specific factual issues that may only be fully understood after a review of a full transcript.
Also, I mean, one of your issues is that there's insufficient factual findings as to the child support guidelines.
Yes, sir.
As I read your worksheet filed September 6, 2006, your worksheet has a net income of the husband of $54,11. The trial court used that $54,11 figure, it appears. The wife's net income on yours was $1,888.67.
Yes, sir.
Now, that would have come out to minimum support obligation of $873. However, don't we have to look at the alimony that's awarded before we go to child support? Doesn't all the law say that?
I think that you're entitled to a credit for the alimony paid. Yes, sir. Certainly the statute requires that.
Okay. Now, the husband also filed a worksheet talking about the alimony. In his worksheet, it's $54,11, and wife's net income of $25,24. And that's $694.47. Are you arguing that that worksheet was wrong?
I think they're all wrong. And let me explain why I think this is problematic and falls into the argument of insufficient findings in this case. If you look at Rule 12.285, and I believe it's sub J, Florida Family Law Rules, it requires in any case that involves a determination of child support that child support guidelines worksheets be filed by each party at or prior to the final hearing. In this particular case, the evidence was closed on July 6, 2006, and I see no evidence that any of these worksheets were filed prior to August and September of the year. Now, there are dates indicated on their certificates of service that still show them post-dating the close of evidence. I see no party's lawyer having made a motion to keep the evidence open. And what I would say is this is certainly a problem. I mean, I'm a practitioner. I do quite a bit of family law, so I realize that it's very difficult to think of all of these myriad of issues in a one-day trial. But certainly, if the rule had been followed and it was required by the judge that they had filed these guidelines worksheets, then he would have had an opportunity.
You know, I got to tell you, I have a problem with what you just said.
Yes, sir.
The rules require certain things to be filed.
Yes, sir.
The trial judge has to make decisions based upon those filings.
Yes, sir.
If somebody's going to practice family law, they should be filing what's required. So I have a tough time saying, well, there's too much to be done.
Well, I don't mean it that they should be excused from it. What I'm saying is, to me, the policy reason for the rule would be that the judge would have an opportunity to review these things, especially the taxation issues, and would be able to identify factual disputes, and by evidence and record evidence then elicited from the parties or witnesses be able to resolve them.
Can't we say here that I'm sorry. Can't we say here, because the calculations I come up with,
Yes, sir.
after you take the alimony off,
Yes, sir.
it's within $10 at the most. And you're talking about a girl that was already 15 years old at the time?
Yes, sir.
So what are you looking at, $360 difference over 3 years?
If that calculation is correct, Judge, one of the things that I pointed out is it appears, and because there's not more specific findings, I can't tell for sure, but it appears that there was a complete failure in calculation of taxation in the husband's income of $1,000 a month, which would tend to overstate his federal tax and therefore understate his income for child support purposes. So I think the calculations are off at least $200 plus a month, whether or not in the worksheet you looked at there was the $1,000 credit for alimony or there wasn't. It's still understated because it appears that one of these worksheets completely failed to take into consideration the federal tax benefit for payment of that alimony. So the problem with the judgment is he doesn't identify how he came to $54,11, doesn't identify how that derived from the $87,000 a year, which is not $54,11, that would be $7,250 gross per month. There's no attachment to the final judgment that indicates that it's of record, and the only things we have are these post-final judgment filings that frankly could be considered argument.
Mr. Snavely.
Yes, sir.
You pretty much used your time, but we'll extend it a little bit. Returning again to the question of whether or not there's competent, substantial evidence to justify this imputation of $24,000 worth of annual income or ability to earn $24,000 a year by the wife.
Yes, sir.
I want to get a little bit clarified on the record, which we can go back and refer to again. Now, there was testimony, wasn't there, that the wife had been compensated at the rate of $24,000 a year while she had worked in the husband's chiropractic office. I know you said that on cross-examination the husband qualified that somewhat, but,
yes, sir.
But wasn't there affirmative testimony to that effect?
I think it was not nearly as specific as that. I went back and looked at that this morning. The exact transcript citation, I believe I had cited in the brief.
Okay.
But my recollection is it was somewhat qualified even when you look at the direct testimony of the husband.
Okay, and the other thing is there was testimony, and I know the wife disputed this, but as I understand it, there was testimony that during the period of separation, the husband talked to the wife about the possibility of having her to return to work in the chiropractic office.
Yes, sir, I recall that.
And he indicated that when the discussion of compensation came up, the wife indicated that she thought an appropriate level of compensation would be $50 an hour. Now, I know she disputes that, but what are we to make of that?
Well, I think when you look at her direct testimony, she felt like after 30 years of marriage and the circumstances surrounding the breakup of the marriage that she shouldn't have to work. But I think what that really goes to in the court's consideration, and specifically the trial judge's consideration, would be whether or not she's voluntarily unemployed, which we've conceded she is. I really don't think that that goes to what her employment potential is. I think there would have to be a specific record made, and there just wasn't.
But it does arguably go to what she expressed as her view of her value, the value of her services in working in that office. Doesn't it? I mean,
I don't think so, Your Honor. The way I took it is that she was being intractable. And I think if you look at his direct testimony, it even says, now look, this is such a wild number, I'm almost embarrassed to say this, but, and he qualified it that way both times that he said it in the transcript. So even I think that he realized that it was more of a, perhaps a spiteful position than it was a realistic explanation of what she thought she was able to earn.
okay. So you think there are questions about the weight to be given to that statement if the husband is believed, and there are questions about the weight to be given to the husband's direct testimony that she was paid $24,000, and there's so much question about the weight of that those two things together don't constitute competent substantial evidence to support the imputation. Is that basically what you're saying?
Judge, what I think is if you look at his direct and cross on the $24,000 payment, you will see that he is not at all, at best he was uncertain that they ever assigned $24,000 from business expenses, and flat out acknowledged she never actually received that as a paycheck.
Okay, we'll study that further. We've gone into your time and you've
yes,
gone
sir,
over,
sorry,
and what we'll do is we'll allow you to have the 3 minutes of rebuttal that I think you requested, and we'll extend the time for the other side too. So if we can put 18 minutes on the clock, and we'll hear from you in rebuttal.
Thank you, sir.
Yes, sir.
May it please the court, my name is Russell Roberts, and I represent the former husband in this case, John Stanley Owens. I'd like to address a few issues. The first issue the former wife raises is that she acknowledges that the court imputed or determined that she was voluntarily unemployed. The former wife asserts in her appellate brief that the trial court should only impute minimum wage to her. But if you look at the transcript from that proceeding, when questioned on examination as to whether she had filed employment applications, had gone to any employment agency.
Whoa. Who has the burden of proof to demonstrate imputation of income?
Judge, I would agree the burden of proof would be on my client.
Okay, and I don't think there's an argument here on appeal that she was voluntarily unemployed. So you win on that.
Right.
The whole issue here is whether the trial court had sufficient evidence to impute $24,000.
Yes, sir, Judge.
So what evidence in this record demonstrates that $24,000 was a fair figure?
Judge, I would submit that the testimony and evidence at the trial court level was that the former wife was paid $24,000 a year from the husband's practice. This practice continued.
Okay, I'm sorry for interrupting. I interrupted you. I'd like you to kind of respond. I know there was
Yes.
testimony she made $24,000 a year. Was there anything to indicate that that was a fair salary or a fair market figure?
Judge, the testimony from the husband was they paid that based on the recommendation of the accountant, and they continued to pay that for a period of time until the accountant advised them otherwise. The former husband also testified that there were jobs available for her to do, and he specifically named 2 job openings. He named a job opening at Dr. Melvin's office and also a job opening at Dr. Gilmore's office, who is an orthopedic surgeon. The husband went on to testify that he believed that she could earn, and this was unrebutted by the wife, that she could earn between $25 and $30 an hour at those capacities. So it's our position, and Judge, the trial court in his ruling on subsections J based his ruling.
You didn't have that in your brief. Where did he testify? Where in the record can I find that?
Judge, I've got it in my brief as far as Dr. Melvin. Those are cited on page 203 is reference to Dr. Gilmore of the trial transcript, and Dr. Welch, I'm sorry, not Dr. Melvin, Dr. Welch, which is page 200, from 202 to 203, he references those job openings.
I know he references the job openings.
Yes.
Did you in your brief say what you can specifically make?
Judge, on page 203, halfway down, I did not in my brief, I said that there were openings both at Dr. Gilmore and Dr. Melvin's office, but on page 2 or 3 of the brief, the husband specifically says she could run Dr. Gilmore's orthopedic clinic well. I'm sure he's paying them at least $25 or $30 an hour. She could surely run his office, and it would grow with her. But in addition to that, the trial court judge based his finding on her ability to earn a living not only on her earning and skills, he also, or on her past income, he also based it on her skills and experience as an office manager. And what the case law says is that you're to look at her past earning history, her skills, abilities, and the opportunities that are available to her. All of the evidence was presented to that. Testimony was heard about her skills, her prevailing earning ability, and the job openings that the husband was aware of that were there. The former wife, and while she has conceded that she made no effort to secure employment, she asserts that you should base it just on minimum wage. But the problem with that argument is that she never went to see if she could earn more than minimum wage. So, and to get to opposing counsel's argument that it should be remanded for no further proceedings, we would say that that was patently unfair because the job market changes. We're talking about a year that has passed between the time this case has been heard and today's date. Furthermore, he asserts that the trial court did not make any other findings as it related to the Social Security. The former wife in this case, and the reason the child support guidelines were not filed, I agree the rule says they're to be filed. There was a dispute as to both parties' income. In this case, the former wife filed a financial affidavit or faxed it the night before the trial that was unsigned. She presented an amended financial affidavit the day of trial which reflected different incomes. At the conclusion of the hearing, the court instructed the attorneys of record to prepare equitable distribution charts as well as child support guideline worksheets. The worksheet the former wife's attorney prepared, if you look at the testimony, the court adopted the income that the wife's expert determined, which was a gross annual income of $87,000 per year. The former wife's expert was asked, was this prior to the deduction of any withholding, Social Security, and Medicare? And the expert specifically said that it was. The court adopted that. The former wife's attorney, at the conclusion of the hearing, filed a notice of calculation of net income. In that determination, she determined that based on an annual gross income of $87,000 a year, the former husband had a net income of $5,411. That is the income that the trial court adopted. Once the equitable distribution charts were submitted, as well as the child support guidelines, the court issued a subsequent letter and instructed the attorneys to prepare additional guidelines based on an income of $5,411 to the husband, potential alimony of $750 a month to the wife. I submitted and filed that second child support guideline worksheet is the one that you referenced, and it specifically referenced the one that of mine that's dated August 21st, 2006, references the income based on the court's preliminary ruling that it would be $750 a month alimony and $5,411 and $24,000 gross to the former wife. The former wife's attorney never submitted a subsequent, despite the trial court's request, never submitted another child support worksheet. If you review the child support worksheet, there was an attachment of the child support calculations. The child support calculations took into consideration the alimony issue, the tax consequences that would have on the former wife. The situation you have here is you have a 16, almost 17-year-old child. and you have a situation with the alimony difference, if this were a modification, the former wife would have to prove a difference of $50 or 15%. The child support difference that we're talking about is not even a basis that she could have sought a modification. In our child support worksheet that was filed based on $750 a month alimony and the former husband's net income of $54.11 and the wife of $24,000 gross a year, the child support that we submitted to the court was $733.05. The court ultimately awarded $1,000 a month alimony to the wife, which would affect those numbers, and the court ultimately decided that the former wife's child support obligation was $707 a month. I would submit that there was substantial competent evidence in the record that established what the former wife's earning ability was based on her prior employment history, the skills and abilities that she has, and the jobs that were available in the area. And I would submit that if the court determines that there is insufficient evidence and it decides to remand, that it should reverse and remand for further proceedings, because the market certainly has changed, and there's a question as to whether the wife since that time has sought employment. In her second assignment of error, the former wife asserts that the court miscalculated the former husband's net income, and I would disagree with that. The court determined the former husband's net income based on the former wife's expert witness at trial. The court adopted that expert witness's calculation. We would also submit that the child support calculation was not error, and there's not a basis for it to go back to the trial court. The former wife asserts that her alimony award was insufficient. She asserts that she needs more than the $1,000 a month that the court awarded her. But if you review her financial affidavit and the trial court judge's detailed findings of fact, the trial court judge determined that she had demonstrated a need for $2,639 a month of monthly expenses. The court awarded her $1,000 a month in alimony, $707 a month in child support, and further determined that she could make a gross of $2,000 a month. Interestingly, the former wife's attorney filed a net calculation of alimony available and represented to the court that based on their calculations, the former husband only had $1,152 a month to pay alimony to her. What was failed to be included in the former wife's numbers is that the court ultimately awarded both mortgages to him, which were $1,674. In addition, he was awarded all of the marital debt. By adding those up, there was actually less than was represented to the court available for alimony. But nonetheless, the court awarded the wife within $150 of her request for what she represented was available for alimony. We would again submit that she got essentially what she had asked for within $150, but she complains to this court that the court erred. The court made detailed findings of fact as it relates to the alimony and the basis and how the court calculated the amount. And so we would submit that that issue is also without merit. In looking at the attorney's fees issues, these parties maintained basically one account. Their business, their personal, and all of their expenses were paid out of this account. During the separation of the parties continued to function out of this one bank account. That bank account paid for all of the expenses. The former wife used that bank account to pay her first attorney a retainer of $5,000. She then used that account to pay her second attorney an initial retainer of $2,500 plus additional payments out of that account. So in essence, the husband was contributing to the wife's attorney's fees because all of those fees that the wife paid were coming out of that account, albeit the husband's fees were also coming out of that account. In looking at the denial of attorney's fees, the court determined that the husband, during the pendency of this case, which was for quite some time, paid all of the living expenses for not only the wife, but the minor children. If you look at the equitable distribution scheme, the alimony awarded to the former wife, and the substantial assets, she walked out of the marriage debt-free. We believe that the trial court was correct in the denial of the attorney's fees to the former wife. The last issue that the former wife raised...
Are all of those considerations in play in connection with the motion for attorney's fees on appeal, Mr. Roberts?
Judge, I believe those would be in play, as well as you have a somewhat unusual issue because during the pendency of the appeal, we don't know what the income of the parties has been, and those could have changed somewhat. The husbands may have gone up and down, and the wives may have gone up and down, but the same considerations for the trial court denial of attorney's fees, I think, would be before this court.
We don't have an invasion of marital assets by either of the parties now, since the time of the entry of the final decree. Obviously.
I'm sorry?
We don't have invasion of marital assets for paying lawyers since the entry of the final decree, because there aren't any marital assets anymore. But
correct.
So that part of the equation is not involved, and whether or not the husband has been paying anything in excess of what he's been ordered to pay, of course, we don't have any way of knowing that.
Yes, sir. But in looking at what he is paying, the court determined at the trial court level that the wife was in as good as a financial position as the former husband was at the conclusion of the marriage based on the division of the assets and the liabilities and the awards that she was awarded. The court determined that she was in just as superior financial position as my client was.
I understand that, but you know, you keep emphasizing, and I think appropriately so, that some time's passed since,
Yes.
Since the time the final decree was entered, and circumstances might have changed.
Yes, sir. I would submit and ask the court to rely on our response that we filed to the appellant's motion for attorney's fees as the basis for our denial of that. In her last assignment of error, the former wife asserts that the court erred in dividing the uncovered medical expenses 50-50 or basically equal. The child we have here is 16, fixing to be 17 years of old. There was no testimony or evidence that this child had any health-related problems. The former wife on testimony, when I questioned her at the trial court level as to how those fees and expenses should be divided, said that they should be split. She did not testify that they should be apportioned or pro rata. She said that they should be split. And so we would submit that the trial court level did what she asked, and therefore under the existing case law, she cannot come before this court and complain that the trial court erred. The trial court divided the medical expenses 50-50, which is specifically what she asked for the trial court to do. I think the major concern that is before the court is the trial court's imputation of income of $24,000. And again, I would submit on behalf of my client that there was substantial competent evidence of her earning ability. She worked throughout the course of the marriage in Dr. Owens' office. She continued to work there for breaks and periods of times during the separation. But we do believe that there's substantial competent evidence that she could earn the $24,000 a year, that she has the skills, experience, and ability as an office manager. He testified that there were openings at other doctors' offices in the area. There was no rebuttal from the former wife that she could not have obtained any of those jobs, and so we would submit that this court should affirm the lower court's ruling.
Thank you, Mr. Roberts. And Mr. Snavely, you have about 3 minutes for rebuttal.
Yes, sir, Your Honor. If you will allow me, when we started this, there was some question about the testimony, and I would direct the court's attention to the transcript, volume 1 at page 156, as the first of the citations, and that was direct of the husband, where he said at line, and I'll start reading at line 8, page 156, until the accountant said it would be better to shuffle it around, so it was like $24,000 a year. What year did you stop making? I don't recall. Approximately 1998, sound correct? Yes. Up until then, she was paid a salary out of your office? Yes. And then based on the accountant's information, you all quit paying a salary to her? Yes. Then, at page 194 through 195, there was further reference of this. And page 194 at line 17, there was a question, now mostly she did not get paid for that work, is that right? And the husband responded, like I did? Well, my point is she had everything she needed. And if the money was in the bank, she could spend it. And as far as we documented it with the IRS, exactly her making a particular amount, I don't know that we did. So it's very clear when you look at the transcript as a whole and the evidence as a whole.
Do you have page 203 there?
Yes, sir, I do.
You heard the testimony about $25 to $30 an hour in the other doctor's office?
Yes, sir.
Does that reflect that, and how do you respond to that?
What I would say is, let's see, I think she's qualified at line 9, his answer to the question, she could run Dr. Gilmore's orthopedic clinic well. He didn't say there was a position open or available, mind you. He just said that she could run Dr. Gilmore's orthopedic clinic. And I'm sure he's paying them at least $25 or $30 an hour. He didn't say he knows what he's paying them. He asked Dr. Gilmore what he's paying her. He has any information whatsoever. He just says, I'm sure that. So
and that's around page 200, 202, something like that?
I have all of these. Oh, that was 203, that little colloquy. I'm sorry, from lines 7 through 13.
Okay.
Yes, sir. So it seems very clear to me that it was far from very clear that as far as a specific amount, what the evidence did show is that they were simply living out of their office account, and they both wrote personal checks on it willy-nilly, and she never actually received a salary, is what it seems to look as a whole to me. And he clearly said in the cross-examination sections that her Social Security would not have reflected $24,000 and all of that. So I just think the record is just not nearly properly developed to support that $24,000 imputation. I will say one thing, Your Honor. There is this talk when we were talking about the child support. There was a talk about subsequent letter that I don't see it of record anywhere. Now, I'm not saying it doesn't exist. I actually know that it does. But I would point out, if we're going to consider the court's subsequent directions after close of the evidence, then probably that letter should have been supplemented in this record, so you can also see that there are some discrepancies in that letter about what the court thought the incomes were. Because when he mentioned 5411 in that letter, he also said this is pre-tax amount, when he'd already said that the expert's finding was $87,000 a year. So, thank you for your time.
Okay, thank you, Mr. Stanley, Mr. Roberts. Thank you both. That completes our calendar for the afternoon. The court will be in recess.